Chapter 9. Action of Covenant. Sec. 47. Defined. Covenant was an action for the recovery of damages upon contracts by deed or under seal, as upon articles of agreement, awards, charter parties or affreightment, policies of insurance, indentures of apprenticeship, leases, mortgages, deeds, and was either for the non-payment of money, or for not doing or forbearing some other act. Covenant is a remedy provided by law for the recovery of damages, for the breach of a covenant or contract under seal. Covenant can only be maintained upon a writing under seal. If a contract be unattested by a seal, or is unwritten, the action by which redress can be had, for a non-performance, is debt or assumpsit, or either according to the subject matter. Sec. 48. Of sealed instruments. The action of covenant, lying only where the instrument is actually signed and sealed, magnifies the importance of this class of obligations. Anciently the use of seals was confined to kings and great men, their use finally becoming common. An interesting case, in the King's Bench, in 1765, Billens v. Van Meerop, is reported in 3 Borough, 1663. White, a merchant in Ireland, desired to draw upon Pillens, who were merchants at Rotterdam in Holland, for £800, payable to one Clifford, proposing to give them credit on a house in London for their reimbursement. The plaintiffs desired a confirmed credit on a house in London, as a condition of accepting the bill. White names the house of the defendants, and offers credit upon them. Whereupon plaintiffs, Pillens, honored the draft, and pays the money. Whereupon plaintiffs, Pillens, wrote defendants, Van Meerop, desiring to know whether they would accept such bills as they, plaintiffs, should, in a month's time, draw upon the said Van Meerops in London, for £800, upon the credit of White, and they, having received their assent, accordingly drew upon the defendants. White failed before their draft came to hand. The letters were offered in evidence. The question was whether the letter whereby Van Meerop undertook to honour the plaintiff's bills was nudum pactum. Lord Mansfield argued that it was. The verdict was for defendants. Justice Wilmot set the verdict aside, granting a new trial, saying that he could not find that a nudum pactum evidenced by writing has been ever holden bad, and held it good. But the House of Lords, in 1797, in Rann v. Hughes, 7-term Rep. 350, held that decision erroneous, saying, all contracts are, by the laws of England, distinguished into agreements by specialty, and agreements by parole, nor is there any such third class, as some of the council have endeavoured to maintain, as contracts in writing. If they be merely written and not specialties, they are parole, and a consideration must be proved. The early common law conception was that the seal gave the instrument legal efficacy, the courts not permitting the same to be impeached on the ground of want of consideration. But after the theory that consideration was what gave life to a written instrument was adopted, the rule prevailed that sealed instruments imported consideration. An instrument which is unsealed could not be converted into a sealed instrument, though in writing, by a written recognition under seal, so as to authorize an action of covenant to be brought thereon. The bare signing and sealing of an agreement makes it a covenant. It was necessary that the declaration in covenant should use words therein showing the instrument sued on to have been a sealed writing. Anciently the words sigillatum et deliberatum were required. But now, 1728, it is held well enough to call it factum, indentura, scriptum indentatum, which imply the circumstances of sealing and delivery. If a contract be properly sealed in the first instance, but is later modified or changed in terms and conditions by parole agreement, an action of covenant will not lie thereon for each breach. The appropriate action upon such an instrument is either debt or assumpsit, according to the subject matter. Sec. 49. History of the action. It is found in the Register of Writs, and is met with in the latter years of the reign of Richard I, 1189 to 1199. And in the first years of the reign of John, 1199 to 1216, it is not mentioned by Glanville, 1154 to 1189, but is described by Bracton in the reign of Henry III, 1216 to 1272, when it could be had as of course, at all events, when the tenement to which it related was of small value. Its form is given in the statute which introduced English law into Wales in the reign of Edward I. In A.D. 1284, there was a period in the history of the action when it was resorted to for the recovery of land together with damages. This occurred where land was leased upon stipulated rental upon condition that if the rent be not paid the lessor might enter upon and hold the land. And again, it was used in actions upon a covenant to convey land, in which it was sought to compel the covenanter to keep his covenant. If he had the lands, the covenantee was entitled to recover them in the action, as well as damages. Sec. 50. The Declaration. The declaration in covenant must disclose a contract under seal, and set forth so much of the instrument as may be necessary for the maintenance of the action. It was necessary that it contain an allegation showing the instrument to be sealed, factum, indentura, scriptum inentatum. Profit had to be made of the instrument or a valid excuse made for failing so to do. Plaintiff could not set forth matter of fact in his declaration not contained in the deed itself, so as to alter the case. All such matter of fact so averred was immaterial. Sec. 51. Writ of Covenant. George III, by the grace of God of the United Kingdom of Great Britain and Ireland, King, Defender of Faith, to the Sheriff. Greeting, command C. D. Late of. That justly and without delay he keep with A. B. according to the force, form, and effect of a certain indenture in that behalf made between them, as it is said, and unless he shall so do, and the said A. B. shall make you secure of prosecuting his claim, then summons by good summoners the said C. D. that he be before us, on. wheresoever we shall then be in England, or in C. P. before our justices at Westminster, on. to show wherefore he hath not done it, and have the names of the summoners, and this writ. Witness ourself at Westminster, there. Day of. In there. Year of our reign. Sec. 52. Form of Declaration of Covenant, in the King's Bench. Term. In there. Year of the reign of King. London, to wit, C. D. was summoned to answer A. B. of a plea, that he keep with him the covenant made by the said C. D. with the said A. B. according to the force, form and effect of a certain indenture in that behalf made between them. And thereupon the said A. B. by his attorney, complains, for that whereas heretofore, to wit, on their day of in the year of our Lord at in the county of by certain indenture then and there made between the said A. B. of the one part, and the said C. D. of the other part, one part of which said indenture, sealed with the seal of the said C. D. the said A. B. now brings here into court, the date whereof is the day and year aforesaid, the said A. B. for the consideration therein mentioned, did demise, lease, set, and to farm let, unto the said C. D. a certain mess wage or tenement, and other premises in the said indenture particularly specified, to hold the same, giving the term, and the said C. D. for himself, his executors, etc. did thereby covenant, promise and agree to and with the said A. B. his heirs and assigns, amongst other things, that he, the said C. D. his executors, administrators and assigns, should and would, at all times during the continuance of the said demise, at his and their own costs and charges, support, uphold, maintain, and keep the said mess wage or tenement and premises in good and tenantable repair, order, and condition, and the same mess wage, or tenement and premises, and every part thereof, should and would leave in such good repair, order and condition, at the end of the said term, as by the said indenture, reference being thereunto had, will, among other things, fully appear, by virtue of which said indenture the said C. D. afterwards, to wit, on the 25th day of March, in the year aforesaid, entered into the said premises, with the appurtenances, and became and was possessed thereof, and so continued to the end of the term. And though the said A. B. hath always, from the time of the making of the said indenture, hitherto done, performed, and fulfilled all things in the said indenture contained on his part to be performed and fulfilled, yet protesting that the said C.D. hath not performed and fulfilled anything in the said indenture contained on his part and behalf to be performed and fulfilled. In fact, the said A.B. saith that the said C.D. did not, during the continuance of the said demise, support, uphold, maintain and keep the said mess wage or tenement and premises in good repair, order, and condition at the end of the said term, but for a long time, to wit, for the last 3 years of the said term, did permit all the windows of the said mess wage or tenement to be, and the same during all the time were, in every part thereof, ruinous, in decay, and out of repair for want of necessary reparation and amendment. And the said C.D. left the same, being so ruinous, in decay, and out of repair as aforesaid, at the end of the said term, contrary to the form and effect of the said covenant so made as aforesaid. And so the said A.B. saith that the said C.D., although often requested, hath not kept the said covenant so made by him as aforesaid, but hath broken the same, and to keep the same with the said A.B. hath hitherto wholly refused, and still refuses to the damage of the said A.B. of pounds, and therefore he brings his suit, Sec. 53, plea in bar, by way of traverse. In covenant, on indenture of lease, for not repairing in the King's Bench, term, in the year of the reign of King George IV. C.D. at A.B., and the said C.D., by his attorney, comes and defends the wrong and injury when, and says that the said A.B. ought not to have and maintain his aforesaid action against him, the said C.D., because he says that the windows of the said tenement were not in any part thereof ruinous, in decay, or out of repair, in manner and form as the said A.B. hath above complained against him, the said C.D., and of this he puts himself upon the country,